segment of this webinar, which is an interactive panel discussion. As I mentioned earlier, we have received a few questions already from the attendees, and we will be taking those up shortly. I first and foremost want to remind everyone that you can send in your questions live to us using the chat option on your screens, and we will take this up as the dialogue progresses. Darren, let me direct this first question to you as it pertains to pharma mergers in the US. What type of remedies have been offered in pharma mergers in the US, and has any pharma merger been blocked till date?
Yeah, so typically pharmaceutical industry mergers are conducted by the Federal Trade Commission. As I mentioned before, that agency is responsible for pharmaceutical enforcement generally in the civil space. There have been a lot of pharmaceutical mergers that the FTC has reviewed. They typically review, several in a typical year. And the typical remedies for a pharmaceutical merger is divestiture of an overlapping product, assuming that a remedy is required. The type of antitrust analysis the FTC does is typical in the pharmaceutical sector as in other industries. They look at the number of competitors in the industry, market shares, pricing in the industry. Potential competitors are obviously very important in the pharmaceutical space, and will define markets and then try to evaluate the competitive effects from the transaction. If there is a conclusion that a relief is needed because the transaction will reduce competition, as I said, the typical remedy is divestiture of one of the overlapping product lines. And so in that case, the acquiring company would decide whether to divest its own overlapping product or the target company's overlapping product. Typically, there would be some discretion as to which it could divest, but that would need to go to another company that is typically not already producing a product, that specific product, but that has the capability of being a successful competitor in that space. And so typically there would be licensing of IP. There may be actually even a divestiture of manufacturing facilities if that were needed, as well as short-term transition agreements to help the divestiture buyer in the short term to take over the product line, marketing, and so forth. And so there may be some, a couple, 2-3 years of a transition process before the divestiture buyer is fully operating on its own with the divested product line.
Thank you for your response, Darren. Let us build a little bit more on this, Ravi. What kinds of modifications can be directed by the CCI when it finds an AAEC in a transaction involving a pharmaceutical company, and can the pharmaceutical company offer any modifications?
So, very similar to what Darren explained from the US perspective, under the Indian law as well, where the CCI during the course of a merger assessment comes to a view that the transaction is likely to present competitive concerns, and the legal standard that we adopted in is called appreciable adverse effect on competition, AAEC. So where the CCI comes to take a view that there is likely to be an AAEC, they have 3 options. The first option is they can block a transaction. The second option is that they can approve the transaction with certain modifications. And the third option is that where the parties are able to convince the Commission that the transaction does not require any interference, the CCI can perhaps also go ahead and clear the transaction without any modifications. Now, as I explained in the earlier part of the presentation, so far in the 8 years of merger control that we've had in India, the CCI has received 56 notifications pertaining to the pharmaceutical sector, out of which they have approved 43. And there have been instances where the CCI has had to step in and order modifications. In fact, in one of the first ever cases of the CCI directing a divestiture pertaining to the Sun-Ranbaxy transaction. And what the CCI found in the Sun-Ranbaxy transaction was that there were certain drugs where in the identified relevant markets, the combined market share of the parties would have been very, very significant, and therefore the CCI directed the parties to divest 7 brands, which interestingly were acquired by a company called Encure, which is currently under investigation in the US in the price fixing case. There have been other instances where parties have upfront offered commitments and divestitures because they have taken a view that there is likely to be a competition concern in the transaction. And this has, of course, been viewed very, very positively by the Commission. So the parties walk up to the CCI with a notification and with a backup plan in terms of the divestment options. The CCI has had an opportunity, even in the pharmaceutical space, in Abbott St. Jude, to actually take the party's plan on board and approve the transaction on the basis of the party offered divestment option. There have been a couple of other cases where the CCI has directed not structural changes, but essentially behavioral changes. We've had instances where the CCI has asked parties to reduce the duration of non-compete clauses, from 8 years to 4 years, and that seems to be the standard that the CCI applies in cases that involve non-compete obligations. So yes, to answer your question, Ashutosh, there are instances where modifications have been ordered, and the CCI has done that both on its own and on the basis of plans suggested by parties.
Thank you, Ravi. We just received this question which seems to be right up your alley, so I'm going to direct this to you. Can exchange of technical information between competing pharmaceutical companies seem to be anti-competitive in India? And can sharing of information between group companies similarly invite CCI scrutiny?
So, there's no bright line test in India when it comes to sharing of technical information. The basic rule under the Competition Act is that competitors should not be exchanging sensitive information. Any information that reduces the necessary degree of uncertainty that should exist in a market is clearly frowned upon. But one of the provisions under Section 3, which deals with agreements, is that it allows competitors to actually form joint ventures. And in creating those joint ventures, if they are able to justify the efficiency gains, these joint ventures are not really frowned upon. The CCI has not yet had an opportunity to examine an efficiency-enhancing joint venture between competitors. But the general understanding is that if sharing of technical information is something that is necessary to achieve the objectives of a joint venture of this nature between competitors, then perhaps it can pass muster. But in any other circumstance, exchange of technical information which allows the parties to somehow game the system or to game the market, the CCI can very well have jurisdiction. As between group companies, the law doesn't provide for it expressly, but agreements and arrangements between companies belonging to the same group are usually allowed. That is pretty much the test that is followed even in the European Commission. But if the group entity in the upstream market is also, for instance, a supplier to other companies in the downstream market in addition to its own subsidiary, perhaps sharing of information between the group companies which impacts the market, the downstream market in a negative way, that is something that the CCI can very well look at. We've had instances of that in different sectors, not in the pharmaceutical space, but there have been instances where an upstream dominant supplier has a subsidiary in the downstream market and has offered favorable conditions and market information to its downstream subsidiary, which has allowed the downstream subsidiary to somehow compete on terms which its competitors were not able to offer.
Thank you. Darren, the same question for you as well. Would you care to elaborate on this from the US perspective?
Sure. Yeah, the answer is very similar in the United States. But I would say in terms of the exchange of technical information, it's really going to depend on what that information consists of. The concern under the antitrust laws is with respect to the exchange of competitively sensitive information. So these are things related to price, output, future strategies, things along those lines. So when companies exchange non-public, competitively sensitive information, that tends to raise concerns with antitrust enforcers. Other types of information that's shared between competitors may not raise the same kind of concern. So efforts by pharmaceutical companies, for example, to exchange best practices on safety, practices on reducing environmental impact, things along those lines, are generally going to be considered to not raise significant antitrust concerns, so long as there are appropriate protections in place to make sure that discussions stay limited to appropriate topics and avoid the concern that we always have when you have competitors in a room together, that discussions may stray into inappropriate areas. As Ravi said, if you have a joint venture, that, assuming it's a legitimately formed joint venture that has integrated its assets, that generally would provide another mechanism for exchange of competitively sensitive information within the joint venture. On the second part of the question, in terms of group companies, so in the U.S., generally a company can exchange competitively sensitive information with its subsidiary, assuming it's a majority-controlled subsidiary. Those would be considered one entity for purposes of U.S. antitrust law for the most part. And so there would be no prohibition on sharing competitively sensitive information or agreements between a parent and a subsidiary that involved pricing or other conduct that might raise concerns if they were independent companies.
Thank you very much. Let's move on to the topic of drug pricing in the pharma industry, which is a perennial topic that keeps on coming up in this industry. Darren, question for you again. Has pricing conduct been scrutinized in the U.S. and have high prices held to be abusive?
No, so the U.S. antitrust laws do not prohibit high prices by themselves. There needs to be some kind of what we call exclusionary conduct for there to be a violation. This is a bit of a difference between the U.S. and some other jurisdictions in Europe, for example, which prohibit what's called exploitative abuses, which is another way of saying high prices. We simply don't prohibit high prices in the U.S. The Supreme Court, in the Trinco decision, which I guess was about 15 years ago, actually said high prices actually have a real benefit in the economy by stimulating competition. When one company sells a product at a high price, that encourages other companies to come into the market and to compete with them. And so U.S. antitrust enforcers have been very careful not to challenge high drug prices or other high prices for that matter. The U.S. Congress, I was mentioning this before, has had a lot of concern about high drug prices and asked the Federal Trade Commission recently to re-examine whether the FTC has any basis to challenge high drug prices standing alone. And as I mentioned before, the FTC issued a report saying that they just don't have that authority. And that's a statement you can find on the FTC's website. I think it came out in the last month or so. I will say that that did lead to some disagreement within the FTC. There's 5 members of the FTC, and 2 of them disagreed with that statement and felt that the antitrust laws might have a way to challenge high drug prices, although they did not really spell out how they thought that could be accomplished under the current U.S. antitrust laws.
Thank you very much, Darren. Ravi, you earlier spoke of CCI's scrutiny of companies in the pharmaceutical sector. Will a pharma company be subject to CCI scrutiny in case it acquires patents or licenses of a competitor?
Well, the answer is yes, and the answer is yes in case the thresholds for acquisition are set out in Section 5 of the Act are met, and these are one of the highest thresholds in the world. So the merger control provisions in India get triggered if there is an acquisition of shares, voting rights, control, or assets. And intellectual property rights like patents are treated as assets under the Indian accounting standards. And therefore, an acquisition of say, a patent portfolio or a IP portfolio will trigger scrutiny by the CCI in case the turnover or asset-based thresholds are being in Competition Act are met, and therefore post-acquisition, the manner in which the acquirer company conducts itself in the market can attract scrutiny under the other provisions of the Act. So, so while from a strict M&A perspective, the trigger is really the threshold. Anything falling below the threshold can be acquired without CCI scrutiny. But beyond that threshold, the CCI will apply its legal standards to determine if such an acquisition of intellectual property rights is likely to cause some sort of corruption that was affected.
Okay, and what about settlement of patent disputes? Will this raise concerns?
This will raise concern, and as Darren pointed out, this is an issue which has already been sort of tested by the U.S. Supreme Court, and within the U.S. legal system, people are still sort of grappling with these sort of settlement cases. In India, we know publicly that there are a couple of cases that the CCI is looking at. Not much is known about these cases, but they all involved agreements between originators and branded generic companies to delay their entry into the market. I mean, there was some settlement agreed between the parties in terms of which the originators would continue supplying their drugs, and for a fee or some sort of consideration, the generics would delay their entry into the market. The CCI hasn't ruled on it yet, but the American case, the activist case, and also a European case, the Lundbeck case, are two cases which the CCI has been looking at very, very closely, and that is most likely to guide the outcome. Traditionally, the CCI tends to lean the European way in terms of their assessment of market and impact on market. So more than activists, I think the Lundbeck judgment of the European Commission is what the CCI is going to be influenced by.
Okay, next question is to you, Darren. What kind of objective justifications are accepted by U.S. authorities to be reasonable patent protections?
So I'm assuming the question is coming up in the context of IP settlements. So how would you defend a pay-for-delay type of settlement provision? So I guess what I could say is, there have been a number of reasons why these cases have failed, and why defendants have won. There are a number of requirements that plaintiffs have to meet. There has to be a large payment, it has to be unjustified. There needs to be causation. Causation can be quite challenging to establish. In other words, there has to be a showing that the settlement agreement actually delayed generic entry. In terms of justifications, what I think is the clearest justification is avoidance of litigation costs. We've seen both the Supreme Court and the FTC accept that as a legitimate justification for these IP settlement agreements. And so to the extent that the payment is relatively low and sort of matches what we might expect for a generic company or branded company to have to pay to litigate the case fully, courts tend to accept those, or at least the FTC so far seems to accept those. And those sort of payments are around maybe the $4 or $5 million range. I think they've gone up as high as maybe $7 million. So that's one area where I think there's widespread agreement. Areas I think that are still getting fleshed out with the courts are the merits of the patent case, for example. If the branded company has a very strong IP claim, could that be a justification for the reverse payment? That is, I think, still being fleshed out by the courts. Also, what is a large payment? The court specifically said that the payment had to be, quote, large. What does that mean? So there could potentially be some justifications around whether the payment is large or not, even putting aside whether it falls within that litigation avoidance bucket. And then, as I said, this is not really a justification, but again, there have been some success with defendants defending these cases on the basis that there was no causation shown between the settlement agreement and the defendant's actions. But I think it's a very good question, and it's one of those areas that, even though we are now 5 or 6 years after the activist decision, this is exactly one of those areas that the lower courts are grappling with. And I think we'll get better guidance on this soon, because it does take, as I've mentioned, many years for these cases to be fully litigated. And questions about justifications typically only come up when you get to the jury trial stage or the resolution, whether it's a jury or a court decision. You typically can't resolve cases based on justifications at the motion to dismiss or summary judgment stage. So I think as we're getting more resolved cases, we may see better guidance on this point.
Thank you, Darren. A participant wants to understand whether private persons or enterprises can obtain competition remedy or compensation if they suffer harm from anti-competitive conduct by pharma companies. Ravi, what are your views on this?
So yes, so the Indian law, the Competition Act in India does allow, number one, anyone can file a complaint before the Competition Commission of India. So there's no locus requirement as such. And what they file is not even a complaint; it's called an information. So they're essentially information providers. So yes, that answers the first part of the question. On compensation, there is a provision under the law which allows parties to file applications to seek compensation for damages or loss that they have suffered by virtue of an anti-competitive conduct. The only sort of qualification for that provision to get activated is that at the first level there has to be a finding by the CCI that an enterprise has actually contravened provisions of law. And secondly, that finding has to be upheld at the first appellate stage. So you need a finding first from the CCI, and for that finding to be verified and upheld by the appellate tribunal before any individual anyone can move an application for compensation. And this, so usually, it hasn't happened in India yet. We know of 2 instances, both in abuse of governance cases where compensation applications were filed with the appellate tribunal, because that's how you file it. You don't file it with the CCI. You have to file these applications with the appellate tribunal. But because there is a final level of appeal to the Supreme Court of India, and all these cases are currently pending, the appellate tribunal has put on hold any determination of these compensation claims pending a final determination by the Supreme Court on the substantive finding of contravention.
Thank you, Ravi. Darren, on the same note, we understand that the U.S. law has provisions for private claims. What is the threshold for claiming damages?
I'm sorry. Did you ask what is the standard for claiming damages?
Yes. What is the threshold for claiming damages concerning private claims?
Okay. Yeah. So in addition to making out a substantive claim, a private plaintiff also has to establish standing. And so let me explain what that means. So the substantive case are sort of the usual elements of an antitrust claim. A private plaintiff, like the government, has to show a relevant market, an exclusionary conduct, or some anti-competitive conduct, typically. A private plaintiff has to do more than that and show that it's actually appropriate to enforce the antitrust laws against that particular conduct. And also that it's been harmed in a way that the antitrust laws care about. So, for example, if there was some anti-competitive conduct for a product that I never used or purchased, I would not be an appropriate plaintiff to challenge that action. And so if I did try to challenge, whether it was in the pharmaceutical industry or otherwise, some action that didn't really affect me, the courts would very likely throw out that claim. So typically, to establish standing in antitrust injury, you need to be a customer of the product. You have to purchase the product, typically directly. All right, you have to be a direct purchaser, at least under federal antitrust law. The other group of affected or injured plaintiffs that could establish standing would be competitors. For certain types of claims, competitors can file claims. This gets tricky because sometimes competitors are actually benefiting from anti-competitive conduct. If your competitor does something to raise prices, typically you would be benefiting from that. So in that case, the courts would also throw out your claim saying that you're not an appropriate plaintiff. We want someone that would actually be harmed from higher prices, and that would typically be a consumer. But again, there are rare cases where a competitor could have standing to bring a claim.
Thank you.
Oh, and let me add just one footnote to that. This is one area where there is some differences between federal and state antitrust enforcement. So there's a Supreme Court case called Illinois Brick, which is what established the need for a direct purchaser under the federal antitrust laws. So a good example of this, how this applies to the pharmaceutical sector, is end users are typically not direct purchasers of pharmaceutical products. A manufacturer typically sells their products to a wholesaler or distributor who then sells it to a local pharmacy who then sells it to the end user. So the end user is not the direct purchaser of the product, assuming there was some anti-competitive conduct by the manufacturers. In that case, the direct purchasers would be the wholesalers or distributors. And so under federal law, only the wholesalers or distributors could sue under the antitrust laws and have standing. Many states have what we call Illinois Brick repealers, where they have passed statutes essentially saying we don't want to follow the Illinois Brick decision. And so in many states, you actually can sue under the state antitrust statutes as the example I gave of the individual that walks into their local pharmacy and is overcharged due to anti-competitive conduct 2 or 3 levels up in the distribution chain.
Thank you very much, Darren. Ravi, a participant wants to know whether overlap with respect to pipeline products would be considered problematic during a combination.
Well, in terms of information disclosure where a transaction is notified to the Competition Commission of India, you have to supply information about pipeline products because market definition is the sort of starting point for any analysis from a technical perspective as well. So parties are required under law to disclose pipeline products, and there have been instances where the Commission has accounted for those pipeline products in defining the market before carrying out an assessment of whether the transaction is likely to cause an appreciable adverse effect.
Okay, great. Thank you. Darren, this last question is for you. I think we are running out of time now. Is there a sectoral regulator to control the distribution of products in the U.S.? And have there been any jurisdictional challenges on this front?
So in the United States, the Food and Drug Administration is responsible for the approvals for both branded and generic pharmaceutical products, and they work very closely with the Federal Trade Commission in the antitrust area. Now, the FDA does not have antitrust authority, so when they observe anti-competitive or potential anti-competitive conduct, they do not have the authority to go into court to challenge that conduct. But as I said, they talk to the FTC quite a bit, and so if they do see concerns, they will refer that conduct to the FTC. And I think, as I alluded to a couple of times in my opening comments, the FDA is trying to do what it can from a regulatory perspective to address some of the concerns, for example, with citizen petitions and REMS abuse, to try to identify anti-competitive conduct quicker and to ensure that there is not any gaming of the FDA process due to anti-competitive conduct. Just follow up to the last question you asked of Ravi, because it's a similar point. In merger reviews, the FTC will also talk to the FDA quite a bit because the FTC wants to know not only who the current competitors are, but who else has filed an FDA application to enter the market. And so they will talk to the FDA to get that information, as well as to talk to other industry participants to understand who else may be a potential entrant into the market.
Great. Thank you for that, Darren. I think that's all the time we have here today. I just want to take a moment to thank both the panelists and to everyone who tuned in, as well as people who sent in their questions. We apologize if we were unable to respond to a couple of the queries, but we will certainly get back via email with our responses to those. Once again, thank you for your time, and thank you for a very intellectually stimulating discussion. Thanks, everyone.
Thank you. Thanks, Darren.
Thank you very much.